All right, our speaker for lunch is Stuart Davidson. Stuart graduated Harvard Law School in 1982. He has since that time devoted his time to representing labor unions, employee benefit plans, and in addition to his work as a lawyer, he's also an educator, a speaker, and an author on many labor and employment issues. Stuart, to just say he's an attorney or a labor attorney, it doesn't really speak to who he is, because he doesn't just practice the law or practice employment law. He lives the life of the law, and he lives that life of the law exclusively on the side of labor. So please join me in welcoming Stuart Davidson.
There is a real assault going on. I don't have to tell you, you are ground zero, because you combine all the things that the right wing hates most. Your union, your public employees, and your teachers. And the truth of the matter is we are seeing an assault on the very existence of the labor movement, and especially on the labor movement in public higher education, and quite frankly, the very existence of available, affordable higher education in America. Let me talk a little bit about agency fee. It's a fixture in many states. It's a law which permits public sector unions to charge non-members a mandatory agency fee insofar as that fee applies to the costs of collective bargaining, contract administration, and grievance adjustment. Such a mechanism was explicitly approved by the United States Supreme Court in a case called Abood versus the Detroit Board of Education. But the first major assault on that occurred in a case called Knox versus SEIU, in which Justice Alito criticized the concept of agency fee. Then more recently was the decision in Harris v. Quinn. In that case, the petitioners supported by the National Right to Work Committee argued that Abood should be overruled. The court did not accept that argument. Immediately following that, the Right to Work Committee proponents decided to pursue a series of cases that were designed to get to the Supreme Court in the hopes that this particular majority would overrule the Abood case. One of those cases I want to talk to you about is Friedrichs versus California Teachers Association. This case is viewed as the next step in the effort of the right wing to eliminate public sector agency fees. And remember, it just doesn't affect you. It's all collective bargaining in the public sector, which is the strongest part of the labor movement right now, is in the public sector, and it is one of the primary support of a progressive agenda. So the petitioners are asking the Supreme Court to overrule Abood and find that any required support for collective bargaining is unlawful. According to most commentators, there's a strong likelihood that the court would overturn Abood. And if they don't overturn Abood, they will certainly create more stringent roadblocks in the ability of unions to collect fair share fees. So I hate to be the Donnie Downer of this conference, but that's not the end of the attack. Let's talk about pension litigation. Public sector employee pensions are under attack around the country. The financial crisis in 2008, the Great Recession and slow recovery that followed, and the election of an incredible number of anti-public sector pension lawmakers all have precipitated a full-scale assault. There are provisions in state constitutions that protect those pension plans. However, in some recent cases, those clauses have not been enough to protect pension rights. And to make no mistake about it, the whole purpose of moving to defined contribution plans and away from defined benefit plans is to shift the risk of market performance from the employer to the employee. So those are the two big bad news things that I wanted to talk about. But there is some good news. on the horizon. I know you've been talking about it, and I'm just going to say a few things about adjunct organizing. In recent years, they've been increasingly visible as they organize and ratify strong contracts. Adjunct professors are also joining with students and parents to create a national advocacy group called the New Faculty Majority. Many labor organizations representing adjuncts have taken a geographic approach, targeting adjuncts in a particular metropolitan area in a single organizing campaign. The strategy is succeeding. In Washington, D.C., more than half of all adjuncts are represented by or have filed election petitions for representation by SEIU and its affiliates. Overall, the best data available indicate that about 25% of what we used to call in Pennsylvania part-time or temporary faculty in the country are unionized. In the public sector, the percentage is higher because many states have relevant enabling legislation that supports part-time faculty's right to organize. But even in states where adjuncts in public sector higher education have no collective bargaining rights, like Colorado, adjuncts have done legislative work around job security and equal pay for community college faculty. And when you consider the fact that universities get, in many places, a tax-free environment, where they suck up city services and pay precious little, the least they could do is treat their faculty fairly. The other last area I want to talk about before you get to your very light schedule for the rest of the day is graduate assistant organizing. Representing graduate assistants, representing adjunct faculty, representing public sector faculty is more complicated and more complex than it has ever been. And at the same time, for all of the right reasons, it is the most important that it has ever been. You are the protectors of an extraordinary legacy that protects the future of America's children and the future of America's security. And no one should ever diminish the value and significance of public higher education, least of all us. No one should take a step back on the value and significance of your work in representing the people that represent the future of America. Thank you very much.